Whenever decisions ought to be taken regarding children, the biggest consideration is the best interest of the child in question. You're welcome to Law Express. My name is Noella Seidu. Stay right there. We're going for a quick commercial break. When we come back, you meet my co-panelists, and then we discuss the topic, custody and access to children. Stay tuned, don't go away.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea butter. Feed your skin right.
Hanifa Yaya. Hanifa is a private legal practitioner. She also enjoys gardening, swimming, hiking, and beach activities. Daniel Paris Siedu. Daniel is a private legal practitioner. He enjoys to spend time with his family. Noella Seidu. Noella is a private legal practitioner and a consistent member of our three lawyer panel on the show. She plays a dual role as the host of the show and likes to play tennis and read.
We cannot talk about custody without mentioning the child and who a child is in Ghana. In Ghana, a child is a person who is below the age of 18. So that is the starting point. Of course, there are other provisions within our law which makes reference to children.
There are different definitions for who a child is. At 18, a child can marry. At 16, because of sexual offenses, a child is said to be defiled when she's 16 years and below. Now, when we talk about custody, usually the natural parents of the children usually will have custody of the children when everything is okay. But when conversations about custody come up, then naturally you see that there's probably the need for one parent or the other, or somebody who is not a parent at all, who should be able to take care of the child. And custody really is the rights and obligations of an adult to take care of the needs of a child. This can be their physical, physiological, educational, biological, clothing, food, or shelter, to take decisions affecting the general well-being of the child, where the child goes to school, where the child lives, and all of that. They all come up in discussions about custody.
Can we now look at the instances where perhaps custody issues come up? You already mentioned that they don't ordinarily happen where everything is perfect. They come up only when there are issues.
Yes, there are instances like you've already mentioned, divorce. Mm-hmm. There is a marital breakdown, and there is separation between the parents, the mother and the father, and the children are involved. Custody comes in to decide who should have the ultimate responsibility of taking care of the child, with whom should the child live. And then when we talk about custody, we also have what we call access. Once someone is given custody, another parent is given access. That is, it is a must that if custody is granted to one party, the other party should also have access.
Yes, and there are instances where custody can be joint. That the parties, if the parties are usually able to agree amongst themselves about how the children should be cared for, then you usually won't see the court intervening. Most of the time, it's the women who naturally have the burden of taking care of the children. Now, so once the parties agree that the custody is joint, then there are instances where they will decide that, okay, the mother will have the children during the week so that the children can go to school. The father can have them on weekends, and then they will share custody during the holidays. Now, you also mentioned access. And yes, access is also not only limited to the natural parents. Sometimes when a non-parent, a guardian of a child, has had access to the child, has had custody of the child, and that custody has been taken away for one reason or the other, the person may be given access to the children. Because remember that the courts or the law looks out for the best interest of the child. The principle is always about what's best for the child and not for the parents or guardians. So, and the court also, the law also looks at protecting the children such that they have continuity in care, familiarity with the people that they have known growing up. And therefore, if, let's say, for example, a grandmother has been the person, or an auntie has been the person taking care of the child, maybe in the absence of the child's parents, and then the child's parents come and take over custody, the law recognizes that this grandmother or auntie who the child has been familiar with should be given access to the child so that the person can visit the child can get to see the familiar person who has always had custody of the child, so that the child grows up in comfort, knowing that, you know, familiar faces are around, people that they usually know.
Security, emotional security.
Yes, yes, yes.
He mentioned joint custody.
Yes.
And it's like we just kind of went over it. But basically, in order to be able to have that to succeed, I think the parties, as in the parents, would have to cooperate in many ways. They will have to have open communication lines, and they also have to plan so that they don't inconvenience the child or disappoint each other.
Yes.
So it means that these kind joint custody would usually be granted where it's perhaps the divorce is not contentious.
Well, you see, joint custody, I understand it, but practically, when you step in court in a family tribunal, they will make two decisions. The applicant who is seeking custody of a child, if he is granted or she is granted, the other party will definitely be granted access. Yeah. Because if you are the mother and you are granted custody, the father will be granted access. If the mother is granted custody, the father is granted custody, the mother will be granted access. The custody is in favor of women most of the time, except when the woman, there are exceptional circumstances, or the woman has behaved in a certain way that the child's best interest will not be served when he lives with a woman.
I think you've gone ahead of the conversation to talk about the considerations for the grant of custody. That is where you are now.
Or the refusal of...
Yeah,
refusal of custody.
But we still haven't actually defined what access is. Most of the conversation has been on custody itself, but access simply, is the legal rights which permits the non-custodial parent to deal with the child or to come into contact with the child at agreed periods of time. So just for the benefit of our viewers.
And it's usually very important because when parents start having conflict, then the the tendency is there for the parent who has custody to deny the other parent access to the children.
More like punish the other party
Yes.
by keeping the children away,
Yes,
holding them.
Yes, or using them as the bargaining chip
Yeah.
to get what they want. And this is not good for the children, because children, the law recognizes that the children need both parents equally. So if adults are having a conflict, it should not affect the children in any way. The child needs to be with the father, the child needs to be with the mother. But if they cannot agree to live together and they decide to live apart, then the children shouldn't suffer. So the access of the non-custodial parent, as you already said, is very important, because we don't want the children to suffer unnecessarily because the parties are not living together.
I think we need to stress this point that once there is a breakdown in the relationship of marriage, children will definitely suffer. The court cannot repair the damage completely. It is good that parents live together, and it is good that children live with both parents. When parents decide to separate, go their own way because of their own problems, then they should know that it will affect the children.
Mr. Asiedu, I agree with you to the extent that perhaps you're looking at a situation where children are living with both parents in a healthy environment. There are some children who are better off living with one parent because of the actions of the other parents. There are also
in the relationship
exactly
when they are living
so
together.
yes, it's true that the ideal situation should be that both parents are together living with their kids in a healthy environment, but where there is maybe violence, abuse and all of that from one parent to the other, even if it's emotional abuse, I don't think you would want your children to live in an environment like that. So in that case, yes, you will still lose, but then it's like you've mitigated the extent of damage that the kids would have grown up with in that environment, just because you want both parents to be present and living with them on the daily. So it's not absolute if you...
Yes, where parents are together and the home is not together, so to speak, and there is fight and all that, and it's affecting the children, as citizens and as people, neighbors, if we observe things like that, the children are suffering, we have the responsibility to report the matter to the Department of Social Welfare, who would intervene. And if it is necessary that the department takes custody of the children, the department will go to court, the family tribunal, and ask for a care order in order to take care of the children. The British say, they refer to it as welfare principle. We say best interest of the child. Welfare principle means that you should ensure that the child, has the best of the situations. I mean, he is not affected emotionally, he's not affected educationally, he's not affected physically, exposed to...
In other words, the natural parents, the biological parents of the children can lose custody of the children if they are not to be taking the best interest of the children at heart in
this
their
happens
dealings.
a lot in the UK. I have had a situation where I have been contacted to do social investigation for a child who was in the UK. The mother leaves for work and leaves the child at home.
Locked up.
So the child found a way to get out and was loitering in the street. The police, arrested. It went to social welfare. So there was the need to take the child away from the mother and bring the child down to Ghana. So they wanted to find out whether there is a relative in Ghana
responsible enough.
And they identified the relative and asked me to go and do the investigation and give them a report. Then they can send the child back to that relative.
We still haven't considered the instances where one parent is just not interested in keeping or taking custody. But before we delve into that and also talk about the considerations for the grant of custody, we'll go for a quick commercial break. Stay tuned, we'll be right back.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
Yes, you're right. There are instances where some parents are not interested in custody of their children. It plays out in many ways. Absentee parent who doesn't contribute to the upkeep of the child is definitely not going to be interested in the custody of the child. But there are even instances when, even in that case, the person who has custody will still need the court to give them legal custody, so that they can take decisions regarding the child by themselves. For example, if you need to apply for a passport for a child, if you need to travel with a child, you need to fill some forms that requires the other parents to also sign. And in the absence of such a parent, once you have an order from the court granting you sole custody, then you can take those decisions regarding the child. There are also some who, out of anger from what has happened in the relationship, would take the anger out on the children and therefore not want to know at all
Just
about the
neglect
custody.
them.
I did a case once when the children were with the man, and when the wife filed for divorce and court was granting custody, he said, you know what, I don't want to know, she can keep the children.
Wow.
Yes, but the judge said, we are not talking about what is good for you or convenient for you. We are looking out for the best interest of the child, and the child needs both parents. So you can't sit in my court and say that you are not interested in what happens to the child. You need to take part in taking care of the child, you know. So
it's not a simple thing of the conflict happens in the marriage, you move out, and because you have the children, you think that automatically you have exclusive rights over the children. You certainly have to understand that you would still need a court order to legally grant you custody if the court is minded to do so. It's not even automatic.
Absolutely.
That by picking the kids and going away, the court will grant you custody.
You have heard about instances where the parties can't even agree about which school the child should attend, for example.
Or which religious training or upbringing the child should have. That is also big within the system.
Yes, yes. So in those instances where you can't agree, then the court will step in if either party decides to apply to the court, so that the court will give directions about why do you want the child to change the school? Why do you want this new school? And sometimes it's just the fact that the person in custody of the children gets to decide everything, and the other party is feeling left out, and so will oppose everything, you know. And the children get caught, which the law doesn't approve of.
We sampled the opinion of people on the streets on this subject matter. Let's take a listen to see what their thoughts are regarding custody and access to children.
Based on the Children's Act of 1998, whoever wants to take or have possession of a child must go to the courts to seek such permission. However, I also think, or it's in the constitution or constitutionally given, or a provision that the views of the child must also be heard first in such situations, whereas the child's view is not able to be picked. Provisions from social department, where the department that takes care of children, a report from that side is also needed to help make a decision as to who the child stays with.
If there is a divorce and a child must decide between the mother and the father who he or she should go to, I feel it would be the mother. Not because mothers are more or greater than fathers, but because like mothers just have the tendency to take good care of kids more than a father.
When there's a divorce, I think the child should go with whomever is physically capable, emotionally capable, financially capable, and will be able to take care of the child very, very well.
In my own opinion, I think the child should stay with the mom because she's loving, she'll have time to get up for he or she. She would should be monitoring his movement or her movement.
The children should stay with their mother because the father is always busy going around doing his work. So the mother will be able to get time for the children so that he'll be able to check whatever they are doing, whether it's wrong or right.
I think the kid is supposed to be with the mother, and until the child is old enough to decide who to stay with, notwithstanding, either of the parents should be allowed to see the kid anytime he or she wants.
The child is, it's a baby. You don't expect the child to stay with the father, regardless of the situation, unless, of course, in special cases where the mother is addicted to certain things that they believe should not have the right to the child.
Well, what I heard, it looks like all those who spoke are actually saying that they prefer that custody is granted to the mothers in case there is divorce. Yes, the law provides that the mother will better care for the child when the child is young. So in considering custody, the law enjoins the judge to take into consideration the age of the children. Even though the law doesn't state specifically the actual age, up to 7 years, 8 years, 5 years, no, it says young child. So normally the court will grant custody to the woman when the child is young. But
I also picked up that one of them, it's quite impressive, their comments. Like the people are quite aware about the issues regarding children and custody and which parents should have them. You notice that one of them also said that there's a point where the child is asked. Mm-hmm. The child's opinion is sought. And so that's feeding into what you were saying about the age at which the court says of age. I think it's from 14 years, isn't it, that the child can be invited by the court to find.
I don't think there's actually a restriction. The requirement is that the child should be able to give a view and independently. As to what age the child can give that independent view to affect the proceedings is not really specified.
Well, at this point, I think that we have to look at the considerations for granting custody by the court. One of them is the wishes of the child. So the child's ascertainable wishes and feelings, how the child feels about going to the mother or the father. The court must take that into consideration. And how does the court take that into consideration? The Department of Social Welfare helps in this direction. in the sense that the court must order a social inquiry report into the home conditions, and interview the father, interview the mother, look at where they are living, and also interview the child. The child can only be interviewed if the child is old enough. The law doesn't state exactly what age, but if the child is able to express his or her feelings, then the court must take that into consideration.
I want to believe that in
order.
Checking whether the child can express emotions is not just a simple thing as to the age per se, because some children are more matured and more expressive than others.
And it also depends on the circumstance.
Yeah.
For example, if one parent alleges that the other parent abuses the child, then the court, even a child as young as 3 years, once the child can talk, 2 years, some children talk very early, 2 years, the court can invite them and speak to them, sometimes without either of the parents, the alleged abuser or the accuser of the abuse, and talk to the children. And if the children are free enough, and that is why these proceedings are held in camera, so that the child is not apprehensive about other people being there, or about the state of the courtroom can be quite frightening sometimes to the uninitiated. So the child is comfortable enough to speak and say what it is that has been happening to the child. So in those instances, yes, there's no age limit at all.
Well, I think that what counsel is saying, I think we are moving into another realm altogether, where the child is in danger, a child is suffering, in the home that he finds himself or herself. So that one is a different matter altogether.
Well, but that is still situated in the situations where custody may be taken away from somebody or refused or granted. Because, I mean, if there's evidence that...
Yes, if there's evidence that there's abuse, and the report shows that, by the social worker, that I went to the home, this is what happened, I interviewed people around, they told me this every day, the child is beaten, he doesn't go to school, he suffers emotionally, he's at risk, and he's exposed to some dangers.
Even some
and so
teachers give information and contribute to the social inquiry report.
So if the social worker does his or her work well, the court will be informed about what is happening at home, and the law says that when the judge orders a social inquiry report to be written, that should be, it shall be taken into consideration when determining the...
So it's time we perhaps look at the next consideration, which is the fact that the courts usually find it desirable to keep siblings together.
Yes, it's one factor that should be and should always be taken into consideration. You cannot separate siblings. So there is a case where a Ghanaian and then a German national married, they divorced, and the German national wanted to go back to her country, and wanted
to choose,
2 children
to choose
to
some
share
of
the
the
children.
children.
The court said that the court decided that no, the children must be together. So custody was actually granted to the man.
Was he the one leaving, or it's the
no?
woman?
The woman who was leaving, the German woman who was leaving. So she wanted the girl, the youngest one, and then I think one of the 2 youngest among the 4 children. The court said because the children siblings must not be separated, so they granted custody to the man who is a Ghanaian and lives in Ghana.
I think then that would be because of the need for continuity
continuity
as
of,
well,
yes.
and of care and control,
Yes.
and as in the environment they are used to.
Exactly, because if the children were in Ghana, then they would have adapted to the Ghanaian way of life with their mother,
the
and maybe
food,
the
the
extended
weather.
family. Yes, they are in school, they've made friends, they have neighbors. So to now pull them out of this familiar, healthy environment to a new, unknown one is something that the courts will look critically at, before the decision is made.
I think parents ought to know that you can only lay claim to just about 50% of the person of your child. So you can pick and choose and say, okay, this is my child of choice, and that's the one I'm going to go with. You have 50% stake in each of them, unless you want to do the Solomon thing where you want to split or cut them into two halves and then go with one half.
There are some considerations in how the parents will decide which child to keep. For example, traditionally you will hear that saying that the boys need their fathers to straighten them up, and therefore the boys should go to their fathers so that the men can raise men, and girls will need to be with their mothers so that the mothers can raise them to be women and to protect them and to keep them safe. Apart from that, of course, if you have two children and one is very troublesome and the other one is easy, if you're given the opportunity to choose, you choose the easier one, won't you?
Well, I think it's also about the bond, because we are humans, and in as much as most parents go like, I don't have a favorite child, the truth is that there's always one that you are more attached to for some reason or the other. For some women, it's the one whose pregnancy troubled them the most, or who they had more pains with, when they were in labor. Like, there are many different considerations. Some mothers would love the son that they had so many daughters before they eventually had. And some would also prefer maybe the brightest child in the house. So there are many considerations.
Yeah.
But bottom line is that the courts would hardly split children,
yes.
And give them to parents in different households. There must be something really, really compelling to get that to happen. We'll go for another commercial break, and when we come back, we would continue with the other reasons or considerations for the grant or refusal of custody.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin, and for all my children, right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
Another consideration for the determination of custody, or who has custody of the child, is sex. Council was saying gender.
I was going to say that.
Well, the law says sex, so I'll use sex. Sex is either it's a girl or a boy. So if it's a girl involved in this separation or divorce, the court is likely to grant custody to the mother. Unless there's a compelling, some reasons why the mother cannot have custody. But generally, the court will grant custody to the mother.
The consideration here is
child.
the biological needs of the child,
Yeah,
and the
biological
support.
needs, yes. Because at that age, if the child is 12 years old, for instance, the child maybe going through this normal puberty, and the mother must supervise that. If the father is remarried, for instance, and has a wife, and the court thinks that the child will be better off, and let's remember that the court's decision is always based on the best interest. And most of the time, we are looking at the interest of the adults instead of the interest of the child, because we take the child as more or less a property. This is my property, I want, without thinking about how your decision will affect the child, you are dealing with. So it's always about the best interest or the welfare principle. What is good for the child is what the court will look at, and not your interest.
Yes, and to add to that, it's true that mothers are preferred to be the primary caregivers of children. However, there are instances where the mother may not be fit to provide this very critical care for the child. A mother may be mentally ill, a mother may be abusive, a mother may find herself in an environment which would teach the child things that the law would frown upon. If a mother is found to be hanging out, prostitution, or hanging out in places where immoral activities take place. Remember that children learn not only from what we tell them, but from their environment also. So in those instances, the court may decide that the child is better placed with the father.
Or other relative.
Or other relative of either the mother or the father, who will provide this best care for the child. In those circumstances, the court will give the custody to even the father, if the father proves to be capable and willing to take care of the child.
So if you're applying, you ought to know that your personal actions will feed into the decision of the court.
Absolutely.
So if you like to fight with the entire neighborhood every weekend or every evening, then you're not fit as a role model to raise the child in that child's best interest.
Absolutely. We don't want to raise future adults in a manner that they cannot fit into society. So the environment is very, very, very important.
Well, one interesting thing is that we talked about prostitution.
Yes.
And you realize that the law talks about prostitution if it talks about children who are in need of care and protection. These are children the social welfare will take charge of and put them in homes and all that. One interesting thing is that where a mother, excuse me to say, is a prostitute,
which is illegal in itself.
Which
is illegal in itself.
The law says that if that trait does not affect the child, then it is not a decision. I mean, the court will not consider that, unless maybe the mother goes, to the prostitution business with the child, and exposes the child and invites customers in the home.
Or perhaps runs a brothel and they live in it.
Where the child is likely
but
to
the
be
mere
exposed
fact that the mother is a prostitute is not, it is not
I would disagree a bit, because prostitution in itself is illegal. It's a criminal offense. It's like saying that if the mother is a drug dealer, that should not be considered. Or a user of maybe narcotic drugs, that shouldn't be considered.
Yes, remember that a prostitute is not a prostitute until the court finds that indeed.
Yes, so where is established? Maybe you've been arrested until the court before.
But the other thing is that it's difficult sometimes to say somebody is a prostitute, and then you go and arrest a person. It says soliciting.
Proof beyond reasonable doubt.
If you go soliciting,
yes,
then if you are found, that is the offense.
Yes.
But to say that I'm a prostitute and I live in my house, and well,
so once you are receiving visitors coming in and out, it's not
soliciting.
automatic.
Yes. And the child is likely to see or hear
that is
those activities.
what the
that's
offense
very
is all
dangerous.
about.
And so under those circumstances where the mother is found to be unfit to take care of the child, or even the father, then access by such persons may be restricted by the court. So you don't just come and take the child and go and do whatever you want to do. The court may give orders that, for example, if the mother is mentally ill, when the mother comes, but still the child needs to see the mother, and the mother comes to visit.
Mother is mother.
Yes. Then such visits must be supervised. So either the father must be present at all times, or she's not allowed to take the child out of the child's residence. Or if the person is abusive, it's been found that the parent is abusive, the child may still need to see that parent.
Maybe in an open space?
Open space, supervised. Yeah. The child may not be allowed to go and spend weekends with such a parent. Over. Yes.
We have some questions coming in on social media, and I think we could look at them and try to answer.
Good evening, Noella and your panel. I want to know, in a situation where both parents are not capable of taking custody of the children, can the grandparents or other family members be considered to take custody?
Yes, if both parents are not capable, and that is the determination of the court, the court is likely to make orders directed at the Department of Social Welfare to look for someone else. And in terms of priority, you look at the other family members, do a social inquiry on them to find out whether they are able, and they remember able and willing, and they don't also pose a danger to the child. So the social welfare will definitely come in, or the court will order for an investigation or social inquiry report to determine who else can take care of the child. When the parents are not able to take care of a child, it means that that child is in need of care and protection. That is where social welfare comes in and goes to court for a care order. The care order places the custody of the child in the hands of social welfare, and social welfare determines where the child should be until a situation normalizes.
Yeah. Yes, and that also dovetails into fosterage, adoption,
guardianship.
Yes. So that outside even the family, the social welfare may find responsible families who don't have children and who are capable and able to take care of the children, will be given the care.
You know, we can't conclude our discussion today without talking about the unlawful child removal. That is where somebody has been given legal custody, and then the other party, in anger or like feeling more deserving, goes to remove the child and then
runs away with
the child. I know somebody that this happened to, where he had legal custody, went to work, came back, and his wife had picked the kids and traveled to another town. And I think we need to advise our viewers that this is unlawful.
It is very unlawful. And the Children's Act states clearly that the person who has custody of the child should continue to have custody. The other person, parent, family member, guardian, neighbor, whoever, has no right to, without the consent and mutual agreement of the parties, remove the child from the child's natural home and take them anywhere. It is not allowed, even if you are the parent of the child, to just go and take the child to another place without a court order, without the consent of the other parent.
So let's look at this scenario where there is misunderstanding at home, in the matrimonial home. The woman decides to pack her belongings and leaves the matrimonial home. Now, by the provision of the law, and leave the children with the father. So the man is the one who has custody. Now, I mean, once you have left the home, because the children are in the home, the man is the one who is taking care of the children now. So that you cannot maybe one day sneak and then remove the children and take them away. That would be against the law. Even though they are your own children, you cannot do that. You must go to court and say, well, I want custody of the children. And the court may grant you custody because the marriage has broken down.
Yeah. Indeed, even if the parent has legal custody, they are not allowed to just take the children and say travel abroad with them without the consent
of the other.
And in most instances, when these issues come up, it's because the parents cannot talk. They can't agree with each other. But for sure, you can't just say, I have custody of the children. I have an opportunity to go to Ukraine. I'm packing my kids, buying a ticket, and then you fly with the children, only for the father or the other parents to come and find out.
Who probably has access.
Who has access. Who has access, only to find out that the children have been taken outside of the country. That is also not allowed.
Finally, we need to indicate that you can, even if you're granted custody, you can still lose it by your actions or inactions.
Absolutely.
So it's not absolute.
Absolutely. If you have custody and you abuse it, the court will take it away from you.
I think this all time would allow us. It's been a very engaging and exciting conversation today. Thank you very much, Lawyer Hanifa Yaya. Thank you very much, Lawyer Daniel Opari Asiedu. We are honored to have had you here today. And we can stress it enough that ultimately the welfare of children is something that the law does not negotiate on. And in everyday dealings with children, we need to be careful how we step, because at the end of the day, we need to look at the ultimate interests of these little ones. This has been Law Express. My name is Mwela Seidu. Thanks for staying with us, and we'll see you again next week. Goodbye.